Okay, let's go.
For opinion and order. This matter comes before the court on review of 3 motions, sanctions and responses. 1. Defendant Patrick Traynor filed a motion for Rule 11 sanctions against Plaintiff's Counsel Nicholas Chiappetta, Esquire, Doc 202, December 10, 2024. Nicholas Chiappetta filed a response in opposition, Doc number 217, on December 20, 2024. With permission from the court, Traynor filed a reply, Doc 227, on January 12, 2025. 2. Plaintiff Danesh Nashirvan, Plaintiff or Nashirvan, filed a motion for sanctions, Doc 266, on March 13, 2025, to which various defendants filed responses in opposition, Docs number 276, 277, 278, 348.1. 3. Defendant Ralph Geramone, MD, PAD, B, a Geramone Plastic Surgery GPS filed a motion for sanctions, Doc 334, on April 21, 2025, followed by a supplemental brief, Doc number 352, to which plaintiff filed a response in opposition, Doc 361, on May 7, 2025. The court conducted an evidentiary hearing from May 19 to May 20, 2025. The motions are resolved as set forth below. Ina Shervin published a TikTok video which depicted an altercation between Jennifer Couture and another woman. At least 2 lawsuits have ensued. In this lawsuit, Nashirvan alleges that defendants, enraged by his publication of the video, began a continuing course of harassment against him. Litigation has not gone smoothly and 3 competing sanction motions are now a separate case alleges that Nashirvan is the harasser, not the other way around. C23 CV 340 SPCKCD, MDFL. Pending before this court, defendant Traynor seeks sanctions against Chiappetta, Nashirvan's attorney, pursuant to Rule 11 for filing a third party's declaration which Chiappetta allegedly knew or should have known was false. Nashirvan seeks sanctions against all defendants pursuant to the court's inherent powers for the use of bad faith litigation tactics, including witness intimidation and harassment. And GPS seeks sanctions against Nashirvan and Chiappetta pursuant to 28 U.S.C. $1,927 and the court's inherent powers for misconduct of the deposition and harassment of one of GPS's counsel, Julian Jackson Fannin. Jackson Fanning 2. The court first sets forth the relevant principles for each of the asserted sources of authority to sanction, Rule 11, the court's inherent powers, and 28 U.S.C. $1,927. A. Rule 11 Rule 11, B, states that, by presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, 1. It is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the caused litigation. 2. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. The factual contentions have evidentiary support or, if specifically so identified, likely have evidentiary support, reasonable opportunity, investigation or discovery. And 4. The denials of factual contentions warranted on the evidence or, if specifically so identified, are reasonably based on belief or a lack of information. Fed. RCIV. P11. B. The Rule 11 standard for the imposition of sanctions has been set forth by the 11th Circuit. Rule 11 sanctions are warranted when pleading or motion has no reasonable factual, 2. Is based on a legal theory that no reasonable chance of success and that cannot be advanced as a reasonable argument to change existing law, and 3. Is filed in bad faith for an improper purpose. Rule 11 imposes an affirmative duty on an attorney reasonable inquiry into both the facts of the law before filing a pleading or motion. When deciding whether to impose sanctions under Rule 11, a district court must conduct a 2-step inquiry, determining 1. Claims are objectively frivolous. The person who signed pleadings should have been aware that they were frivolous is frivolous when it has no reasonable factual basis. A legal claim is frivolous when it has no when the attorney is merely weak, but supports a claim existing law after a reasonable inquiry. Sanctions are warranted, however, when attorney exhibits a deliberate indifference to obvious facts. If the attorney failed to make reasonable inquiry, then the court must impose sanctions despite the attorney's good faith belief that the claims were sound. The reasonableness of the inquiry depends on the circumstances of the case. In addition, an attorney's obligations with respect to the contents of pleadings or motions are not measured solely as of the time when the pleading or motion is filed with or when the attorney, having learned the claims lack merit, reaffirms contained in the complaint were not frivolous that the file does not prevent the district from after it should have been clear those contentions were no longer tenable. Gilsano v. Burlington, Incorporated, 34F, 4th 935, 941-43, 11th 2022. Internal citations omitted. Procedurally, under Rule 11's safe harbor provision, the party seeking sanctions must serve a copy of the motion on the opposing party 21 days before filing a motion for sanctions under Rule 11. Duda v. State Farm Fire and Cass. Inc. Number 23-12788, 2024 WL 3580079. At Star 1, 11th July 30th, 2024. Citing Fed. RCIV. P11. C. 2. B. Court's inherent powers. A court may impose sanctions for litigation misconduct under its inherent power. S. Eagle Hospital. Physicians. Lic VSRG Consulting, Incorporated. 561F. 3D 1298. 1306. 11th 2009. Citations omitted. These powers are necessarily vested in courts to manage their affairs to achieve the orderly and expeditious disposition of cases. In Ros. 65F3D 1567. 1575. 11th 1995. Quoting Chambers v. NASCO, Incorporated. 501 U.S. 32. 43. 1991.